Hello, I think we can start.
Yes, we can start.
Thank you, Your Lordship. Welcome team 106 and 116. If the teams are ready, please convey your time of portion. You may either unmute yourself or put it in the chat box.
May we begin?
I think yes.
Please convey your time of portion.
All right.
It's not the total time, but the individual time that you'll be taking. That is in the format of team 106, speaker 1 time, speaker 2 time, rebuttal time, and so on. Is it clear?
Yes, it's clear.
Team 106. So the time apportionment of team 106, speaker 1, 15 minutes, speaker 2, 15 minutes, and rebuttal time 15 minutes. Team 116, speaker 1 will be given 20 minutes, speaker 2, 20 minutes, and rebuttal time 5 minutes. Please make sure that each participant adheres to the time schedule. So let us begin with the session. Informing once again, we are streaming live on YouTube our current Moot session. Judges and participants, are you ready?
Yes.
Good morning, everyone. It is our esteemed privilege to have with us our judges for quarterfinals, Advocate Nikhilesh N and Advocate Parvati Koto. For the attention of the judges, we have here team code 106 and team code 116, composed of speaker 1, speaker 2, researcher, representing the petitioner, team 126, and team code 116, composed of speaker 1, speaker 2, and researcher for the respondent. I hope the teams are familiar with the rules. Both teams have 45 minutes each for their presentation. Team 106, you will be having 15 minutes each for speaker 1, speaker 2, and rebuttal according to your time apportionment. And team 116, 20 minutes for speaker 1 and speaker 2 each, and rebuttal time 5 minutes. So there will be a warning given for half time, and at the end of 5 minutes, 3 minutes, and 1 minute left. And at last, there is a time over message put up in the chat box. Please make sure that each of the participants monitor the chat box correctly. You may only continue speaking with the permission of the court once after you exceed the time limit. So I think we are ready to begin with the session. Speaker 1 of team code 106. If your lordships are ready, I would like to invite the first speaker.
Yes, please.
May I begin?
Yes.
Good morning, Your Excellencies. If it may please the court, we are IMC 106, and we have the honor to appear on behalf of the claimant, Octa Limited, in the current matter at hand. Octa Limited versus owners and parties interested in MB Moonlight in today's proceedings. Are Your Excellencies familiar with the facts of this claim, or may I assist the court with a brief summary of the facts?
Can you please put in a brief summary?
Yes, Your Lordship. The claimants Octa Limited time chartered MB Moonlight, a vessel flying the flag of Indo for transportation of cargo from the Kingdom of AEU to the west coast of Indo. The charterers later instructed the vessel to sail to Fujairah port at AEU for bunkering, then to Iran for loading cargo, and then finally to Mumbai for discharge on 11th July. On 10th July, the claimant received an email from Moonlight informing them about bad weather experienced, the listing of the vessel at 35 degrees starboard, and the master jettisoning 500 to 600 MT of methanol. On 11th July, the claimants provided the details of the loss suffered to surveyors and loss adjusters from their cargo insurance company. Octa then subsequently requested Moonlight to share the details of the incident which occurred. Moonlight arrived at Mumbai and Octa requested an arrangement of a survey to ascertain the loss. The claimant's surveyors were allowed to enter the ship only after the passing of a few days, wherein later it was revealed in the survey that cargo was short delivered by 650 MT and not 500 to 600 MT as declared. Octa then went to the court and obtained an arrest of the vessel. Moonlight paid security and the vessel was later subsequently released. Thereafter, Octa demanded the release of the cargo, but Moonlight refused on the ground that Octa had to provide general average security. Octa's insurance company provided security for the general average and the cargo got released. The claimant's insurance company is one which is on the SDN list, and a letter of subrogation has been obtained. I will speak for 15 minutes. My learned co-counsel will speak for 15 minutes. And with your permission, we reserve 15 minutes for rebuttal.
Okay.
Your Excellencies, over the course of the next 15 minutes, I will be arguing issues 1 and 5. As per issue 1, I will be submitting that, firstly, in view of the arbitration clause in the charter party, the exercise of the admiralty jurisdiction by the court is valid. And as per issue 5, I will be submitting that the provisions of the Arbitration Act 1996 excludes an action rem from its purview as non-arbitrable. My co-counsel will demonstrate firstly that the declaration of general average is not legally sustainable if the vessel is unseaworthy. Secondly, she will be demonstrating that this court is not bound by sanctions imposed by a third country. And lastly, she will also be demonstrating that the counterclaim of general average cannot be brought before this court because it is to be resolved by arbitration. If there are no further questions, the counsel seeks permission to move to the first issue, that in view of the arbitration clause in the charter party, the exercise of admiralty jurisdiction by the court is valid.
Yes.
I would like to argue the first issue based on two notions. Firstly, it can be considered to be a maritime claim, and secondly, it is for the purpose of providing security against such maritime claim. These will be argued utilizing sections 4 and 5 of the Admiralty Jurisdiction Act 2017, which can be referred to in pages 2 and 3 of the memorial of the claimants under sub-issue 1.1.1. As per the first notion, section 4, clause F of the Admiralty Act 2017 provides the requirements of a maritime claim. Section 4 states that the High Court may exercise jurisdiction to hear and determine any question on any maritime claim against any vessel arising out of any loss or damage or in connection with any goods. In the current matter at hand, the claimant, apprehending the loss of 650 MT of methanol due to jettison by the master, moved the court against the vessel. Now, moving on to the second notion, as per Section 5, Clause E of the Admiralty Act 2017, the High Court may order arrest of any vessel which is within its jurisdiction for the purpose of providing security against a maritime claim, which is the subject of an admiralty proceeding, where the court has reason to believe that the claim is against the owner. In the current matter at hand, the High Court has jurisdiction to order the arrest of any vessel for providing security against the current maritime claim, the validity of which the present counsel has already pleaded for. Furthermore,
court once before. Haven't you approached this court once before for on the same grounds?
Yes, Your Lordship.
Then why are you here before us again? You've already received the security.
Your Excellency, we are approaching the court based on due to the fact that the ship has been arrested and the cargo has not been received as of yet.
But I think the cargo was released. Cargo is already released to you, right?
Your Excellency, sorry, I'm not able to.
The cargo is already released to you, isn't it?
The cargo, yes, the cargo has been released, but the general average security has not been declared as of yet, and the issue asks whether the court has admiralty jurisdiction, and we would like to say yes.
Correct.
Matter.
For the fact that you have approached, I'm just asking you. You have approached us before also. We have given you arrest of the vessel. You have already received a security. As far as your claims are concerned, you are a secured person, as in you can just enforce the security. Now, why are you before us again?
Your Excellency, we would like to. We are approaching the court as. May I take a minute, Your Excellency? Your Excellency, the claimants had demanded the release of cargo, but the respondents had refused on the ground that the claimant had to provide general average security. And our insurance company provided the general average security and the cargo ultimately got released. But however, there is still a dispute regarding such, and we are, that's why we have approached the court.
Okay. Okay.
May I proceed with the arguments? If there are no further questions on the first issue, the council will proceed to address the fifth issue, that the provisions of the Arbitration Act 1996 excludes an action in rem from its purview as non-arbitrable.
How do you get over the fact of the arbitration clause in the end by PE form? Is there a case law in support of your contentions which speaks that I can always entertain your claim even if there is an arbitration clause?
Your Excellency, in the case of, Your Excellency, I will be proceeding with this question in the fifth argument,
Okay.
the fifth issue. May I proceed?
If the coaches does not have any, as in, you can proceed.
For this issue, I wish to make two arguments using two landmark judgments. It can be referred to in page 9 of the memorial under sub-issues 5.1 and 5.2. Firstly, the Indian Supreme Court in the case of Vidya Drolia and others versus Durga Trading Corporation held that disputes are not arbitrable when the cause of action of the dispute relates to actions in rem. Secondly, in the case, the Bombay High Court in the case of JS Ocean Liner versus State of Bombay decided that the nature of an application under the Arbitration Act is distinct from an admiralty action for arrest of a vessel. In this case, the court stated that the right to arrest the ship is a right in rem, and whereas the application under arbitration law filed is a right in personam. Thus, the Indian courts can arrest the ship despite the fact that there exists an agreement for
Counsel,
foreign seated arbitration.
can you enlighten us regarding the basics? That is, what is right in rum and the right in persona? What
Much
is the
obliged.
difference?
A right in rem means the right against the world at large, whereas the right in personam is a right against a specific individual.
How can we apply this concept into the admiralty claims?
An arrest of a vessel is considered to be a right in rem, a right against a world at large, and this has been held in several case laws. And may I take a minute?
Yes.
Your Lordship, the arrest of a ship is a right in rem as the vessel has a juridical personality, and therefore it can be tried by the High Court despite there being an arbitration clause in the charter party.
Okay. Then, in the case of persona,
A right in personam is a right against an individual, and such cases it is arbitrable, and it can be an arbitral tribunal can be approached regarding such.
can you suggest some of the cases supporting your statements?
Much obliged, Your Excellency. In the case of JS Ocean Liner versus the State of Bombay, it was the High Court had decided that the nature of an application of an arbitration act is different from that of an arrest of a vessel, and therefore the Indian court can arrest the ship despite the fact that there exists an arbitration for foreign seated an agreement for foreign seated arbitration between the parties. And also the court in the case of Vidya Drolia and others had held that disputes are not arbitrable when the cause of action relates to action in rem.
Yes. Are you aware about this marine infratech case held 2020 decision? Which clearly differentiates the right in rum and right in personal proceedings in the admiralty claims. Are you aware about that case?
The council pleads ignorance regarding that case.
Yes. Yes, you can
Yeah.
further proceed.
If Your Excellencies does not have any further questions regarding the above issues, my co-counsel will now proceed to issues 2, 3, and 4.
Yes.
Your Excellencies, may it please the court. This is the co-counsel representing the claimants, and I will speak for 15 minutes. As my learned co-counsel stated, I will be submitting that firstly, the declaration of general average is not legally sustainable if the vessel is unseaworthy. Secondly, this court is not bound by sanctions imposed by a third country. And lastly, the counterclaim of general average cannot be brought before this court because it is to be resolved by arbitration. To start off with the second issue, it is humbly contended that it is not legally sustainable to declare general average when the vessel is unseaworthy. Unseaworthiness can arise from defects affecting the safety of the vessel or those affecting the safety of the cargo. This argument is put forth in two limbs. The first being that the owners are in breach of their obligations that are outlined in the NYPE form. Secondly, the vessel is to be found unseaworthy due to the negligence of the master. To tackle the first notion that the owners are in breach of their obligations, it is to be noted by this court that the owners have a strict obligation with relation to the ship's seaworthiness, which is given by clause 2B of the NYPE form. The same details that the vessel has to be seaworthy and there must be a competent master and crew for this certified by the STCW standards. This brings us to the second notion of this argument, that the negligence of the master, which is substantially contended by the factual instances of the problem, further divided into two instances. First is concerning the hidden amount of jettison. It must be noted by this court that in shipping practice, jettisoning is a last resort and it must be employed after all conventional alternatives have been carefully considered by the master and crew. The Roman numeral 1 of the York-Antwerp rules that both the parties have agreed upon to settle general average disputes states and highlights that no jettison of cargo shall be allowed as general average unless it was carried with accordance.
Counsel,
Yes.
again
yes.
goes to the basics. Can you enlighten us regarding the concept of general average?
So yes, Your Excellency. So general average is a voluntary sacrifice at the time of peril, which incurs some expenditure for the common safety of the crew and the vessel.
Then what is the meaning of jettison and the difference between the two?
So Your Excellency, jettison is necessarily throwing off cargo from the ship, but there are other alternatives. I'm not saying jettison is not an expenditure. Of course, yes, it is an expenditure, but jettison is, if it is not done in accordance with trade practice or with caution, I am saying that it can be considered as damage.
Yes, my confusion is that the difference between general average and the last concept jettison.
Okay, so jettison is necessarily, I shall repeat, is throwing off cargo from the vessel.
That is correct. What is the concept of general average? I have some confusion in your submission.
So Your Excellency, general average is a sacrifice that is voluntarily taken up at the time of peril for the common safety of all parties. And you can say the common goal of all parties. In my submission, I am saying that the jettison of our cargo was not for this common adventure or maritime adventure, because I have faced a loss, the claimants have faced a loss, and hence it cannot amount to general average. If I may further clear your suspicion, yes.
You're opposing the concept of or the issue of general average in the capacity of that of the owner of the cargo or the consignee.
I'm sorry if Your Excellency may repeat the question.
You're opposing this issue on the claim of general average on the capacity of the owner or that of the capacity of the consignee.
As the consignee, we are not the owners.
You're not the owners.
Yes.
Okay. Who's the owner of the cargo as per the facts?
Owner of the cargo is us. The claimants are the owner of the cargo.
Okay, so that is why I'm asking you. Are you opposing the issue of general average on the capacity of the owner of the cargo or the consignee of the cargo?
As the owner of the cargo.
Okay.
The respondents are the vessel as well as the crew.
Okay.
That clarification was required. But if Your Excellency doesn't have further questions, should I move on? Or do you want me to clarify the general average and jettison a little more?
Isn't the general average already paid by the insurers?
It is paid by the insurers, but the dispute is whether the issue raised is if it is legally sustainable to ask for general average if the vessel was unseaworthy.
Why are you questioning it? Isn't it supposed to be the insurer's headache? You are
Correct, but
There's already a letter of
there was a letter of subrogation, and hence the claimants, we are representing the interests of the insurance company as well as our interests.
Okay.
Okay. So moving on, if the observer could just inform me how many minutes I have left. And Your Excellencies, if there are no further questions, should I move on with my argument?
Yes, please.
So to further the negligence of the master that I am claiming, we need to note also that the ship listed at 35 degrees starboard side. This listing is at the maximum angle that is detailed in the Solace Convention. And it was a risk undertaken by the master, and hence it can be hinted that there was negligence on part of the master. If Your Excellency,
How do you combine both unseaworthiness and negligence together? Isn't it both different concepts?
no, they are different concepts, but I am linking it and saying that unseaworthiness was caused due to the negligence of the master.
You're saying, okay.
Okay. If Your Excellencies have no further questions, I will proceed to the third issue.
What is your understanding of unseaworthiness?
So unseaworthiness is the state of the vessel that state should perform according to the contract of voyage. It should be able to carry cargo from the starting till the end. There is also a possibility that the vessel can encounter some safety hazards between the voyage. So that can happen, that unseaworthiness can be questioned in between of the voyage as well.
And what about the negligence of the master?
Your Excellency, if you can elaborate.
What is your, when you say that, the master has been negligent in the vessel also, that is the reason why the vessel is unseaworthy. I want you to explain me the concept of the negligence of the master in the case.
The negligence, as in, if I may clarify your question, if it is how the master was negligent?
I'm just asking you to correlate unseaworthiness and negligence.
Okay.
Say that the ship was unseaworthy. You're saying that the master was negligent as well.
Yes.
Understand the relation between the both.
Okay. So the master was negligent is what we are claiming, because the master listed the ship at 35 degrees starboard side. And secondly, the master also negligently jettisoned the cargo. And if I may bring back to the previous Excellency's question about jettison, there was a hidden amount of jettison our surveyors found. The respondents claimed that only 500 to 600 metric tons was jettisoned, but there was a hidden amount of around 50 plus metric tons jettisoned. So why was this amount hidden from us? Hence, we are saying that the master and crew were negligent, and because of this negligence of listing it at 35 degrees starboard side, we are saying that the ship became unseaworthy.
Are you arguing for this negligence or unseaworthiness of the ship?
If you may repeat your question, Your Excellency.
You arguing for this negligence, that's an aspect, or the
Yes.
other aspect, that is the negligence of the master. Because of that reason, the loss happened.
The negligence of the master is because of which the loss happened.
You are claiming negligence,
Yes.
not the unseaworthiness of the ship.
The unseaworthiness of the ship was due to the negligence of the master. He was not able to, sail the ship properly.
Can you show some of the authorities because of the act of the master, this unseaworthiness of the ship occurred? Can you
Yes.
suggest some of the case laws or
I
some other
will,
materials?
yes, council will suggest some authority, but just to inform the observer, if I exceed my time, if you could just let it pass. So, Your Excellency, in the case of Watson and Sons versus Fireman's Fund Insurance, this was a 1922 English case in the UK. I'll quote what the case basically said. If the master is mistaken as to the existence of peril, loss sustained in consequence of his negligent actions, this cannot amount to general average.
Then the ship will have the capacity to overcome all the general perils of the sea. If something unforeseen happened, then only he can seek exemption.
Right.
Whether in this case, how this, why these cargoes were thrown to sea, why this jettison happened?
This jettison shouldn't have happened, is what we're claiming, Your Excellency. There are other alternatives. If there is a ship experiencing bad weather, a little water can be pulled into the vessel to bring the vessel to stability. There are other alternatives. Jettison cargo is expensive. Hence, why would you throw it off board as the first thing?
Okay.
If Your Excellencies have no further questions, I would proceed to the third issue.
Yes.
The third issue is if this court is bound by sanctions imposed by a third country. For this third issue, the Council for Claimants wishes to make arguments based on the notion that the insurance company, which is under the SDN list, is not a USA registered company and has no link with the United States of America. It is humbly contended that the SDN list is a sanction imposed by the US towards individuals and companies. Companies under the SDN list get their assets blocked, which leaves them prohibited to be dealt with by the US authorities. It was observed in Manman Koshet Mining Limited versus Aegis Managing Agency Limited and ORS. This case law can be found on page 6 of my memorandum under issue 3.1. That US sanctions cannot be considered only when there is common ground between the parties on any mediation of US, or if one of the parties were a US citizen or company. In the current matter, if I may have an extension of time, Your Excellencies.
How much time do you need?
10 minutes. I have one more issue after this left and prayer.
I don't know whether it is permissible because there are other participants also, right?
Yes.
I could sum up in
You
5
can give
minutes.
5 minutes now.
Okay. Okay. Thank you, Your Excellencies. So in the current matter at hand, the insurance company, which is on the SDN list, is not an American company at all. And hence, we are claiming that it is submitted that third country sanctions cannot be imposed, and this court is not bound by them. If your excellencies do not have further questions regarding this third issue, the council seeks permission to move on to the fourth issue.
Yes.
Much obliged, Your Excellency. The fourth issue is if a counterclaim of general average can be raised by the respondents against the claim for short delivery of cargo, can this be adjudicated by this court? It is humbly contended that the counterclaim of general average cannot be brought before this court because it has to be resolved by arbitration at Lloyd's London. And this notion is brought forth in the first limb that clause 25 of the N/P form stipulates that general average must be settled pursuant to the York Antwerp rules at Lloyd's London. And secondly, the place and venue agreed by both the parties is Lloyd's London as given in the Moot problem. With regards to clause 25 of the N/P form, it must be noted by this court that charter party wise, the general average shall be adjusted according to York Antwerp rules and settled in US dollars in the stipulated venue according to clause 54 of N/P form, which is Lloyd's London. If Your Excellency do not have any further questions regarding the fourth issue, the council seeks permission to move on to the prayer.
Yes.
So it is humbly prayed by the claimants that this court adjudicate the exercise of admiralty jurisdiction in view of the arbitration clause, to declare that the claim for general average is not legally sustainable as the vessel is unseaworthy, and thirdly, to adjudicate that this court is not bound by third country sanctions. Fourthly, to declare that this honorable court cannot adjudicate GA claims. And fifthly, to adjudicate that the provisions of this arbitration act excludes an action in rem from its purview as non-arbitrable. And for this, the claimants humbly pray. The counsel for claimants rests its case.
Yes.
I think should we have a do this score sheet now? No, right? It's after the.
No, after the whole moot session. So if your lordships are ready, I would like to invite the first speaker for the respondent to speak. Team 116. You will have a total of 20 minutes based on the apportionment of your time. IMC 116 speaker 1 may start now.
Good morning, bench. May it please the Honorable Court and Counsel 1 from the team 116 appearing on behalf of the respondent in the disputed case of Octa Limited Company versus owners and parties interested in MV Moonlight. The council seeks permission to address the bench as your lordship and ladyship. For our proposition and for our most problem, the council 1 will be dealing with issues 1 and 2 and 3, and my co-counsel will be leading with issues 4 and 5. The council seeks permission to explain a brief on the facts of the facts.
Can you tell me what happened in the voyage, maybe? That's all, just that part, wherein from 19/5/21 to 11/7.
Much obliged, Your Lordship. The claimant have chartered a time charter for the vessel for the purpose of transportation of cargo from EU to the port of Indo. On 19th May 2021, the claimant directed the vessel to sail to Fujairah port at EU for bunkering. However, the claimant, after completion of bunkering, instructed the vessel to proceed to BAK Laran for loading of cargo for the voyage to west coast of Indo. There is a political interest at Laran for loading cargo for voyage to west coast of Indo. And due to this political interest, the total control of the port owing to which BAK is regarded as unsafe. The vessel loaded cargo at BAK Laran and 3 bills of lading were also issued from the same spot. On 8th of July 2021, the owners informed the claimant that the vessel is expected to arrive in Mumbai port for the discharge dated to be on the 11th of July. 2021. On 10th July 2021, the claimant received an email from the owner informing that the vessel had experienced bad weather and had listed 35 degrees to starboard side, and the mast of the vessel had to jettison around 500 metric ton to 600 metric tons of the cargo of methanol. On 11 July 2021, the claimant provided details of the surveyors and loss adjusters appointed by the claimant's cargo insurance company and requested the owner to share all the details of the incident with them. When the vessel arrived, thank you. Much obliged. If the council is, if the ladyship is well versed with the facts, shall I move on to my first issue?
Yes.
My first issue, the council seeks permission to address the first issue as that in view of the arbitration clause in the charter party, whether the exercise of admiralty jurisdiction by the court is valid or not. The council seeks permission and honorably submits that the exercise of admiralty jurisdiction by the court is not valid, as the charter party agreement involves the prominence of an arbitration clause which provides for the resolving of all disputes between the claimants or charters and owners by the arbitration itself. So, according to the Chapter 4 of the Arbitration and Conciliation Act of 1996, an arbitration clause which forms part of the contract shall be treated as an agreement independent of the other terms of the contract. So, in this case, the charter party terms, among other things, provides for arbitration in London for resolving all disputes between the claimants or charters and owners. As per your contract rules, any dispute regarding the general average has to be settled in arbitration at Lloyd's London. The fact clearly stated that the central role for arbitration clause, the claims propounded by the claimant such as short delivery of cargo or general average contribution that can be exercised in arbitration at Lloyd's London because it has the power to resolve all disputes between the claimant and the ship owner. Hence, it is humbly submitted before the Honorable Court of India that the exercise of admiralty jurisdiction by the court is not valid because the charter party agreement involves the prominence of an arbitration clause which provides for resolving all disputes between the claimants and the owners. It is also supported by some cases such as in DGS, SGS, Soma JV versus NHPC Limited, which was concerned on an arbitration agreement stipulating that arbitration proceedings shall be held at New Delhi or Faridabad, India. Then the Supreme Court prescribed a bright line test for determining whether a chosen venue could be treated as a seat of arbitration. So in that case, it was held that the seat of arbitration, if has been mentioned, it should be affirmated. Also, in a similar case, it is Roger Shashua and others versus Mukesh Sharma, where the High Court held that the chosen venue, London, was the seat of arbitration because the parties had already chosen the London as the venue for the arbitration and also had not designated any other place as the seat of arbitration. Also, chosen a supranational body of rules to govern the arbitration, and therefore there were no contrary to India. Secondly, there is no scope of admiralty jurisdiction on the same issue. As per the UNCLOS, which formed to ensure freedom of shipping navigation at sea, allowing ships from one country to move safely to and freely in international waters, as established by UNCLOS, the territorial seas, a belt of coastal waters and territorial jurisdiction encompasses territorial waters up to 12 nautical miles from the closest baseline point. So in the case of Latore versus Union of India, that is the Embracalixi case, the Italy has challenged the arrest before the Kerala High Court, alleging that the India had no jurisdiction to try the case at the very first instance, as the incident happened not in the territorial waters of India, but on the international waters. So in this case, the vessel experienced bad weather and had listed 35 degrees to the starboard side, and the mast of the vessel has jettisoned around 500 metric ton to 600 metric ton of cargo of methanol. The claims made by the cargo owner, such as short delivery and general average contributions, are the result of jettisoning of cargo. So jettison of cargo is a matter of issue, and that happened via the voyage of the vessel towards the Mumbai port and not due in the territorial waters. The fact itself is explicit that there is no proof to affirm that the cargo was jettisoned within the territorial waters of the state. Hence, it is humbly submitted before the Honorable Court that the exercise of the admiralty jurisdiction by the court is not valid. There is no admiralty jurisdiction within the territorial waters because jettison of cargo is neither jettison of cargo is a matter of issue, and that the same has happened during the voyage of the vessel towards the Mumbai port of Indo and not within the territorial waters of Indo. there is no evidence also to prove that the jettison of cargo has happened within the territorial waters. So the exercise of
Counsel,
admiralty
can you substantiate your argument by using our available statute, Admiralty Act?
Pardon, Your Lordship?
Which provision of the Admiralty Act that excludes this jurisdiction?
Sorry, Your Lordship, the counsel is not well versed.
So your argument is that the present court do not have the Admiralty jurisdiction, isn't it?
Indeed, Your Lordship.
And what is your opinion regarding the conflict between the arbitration clause and the Admiralty jurisdiction? Arbitration clause in that agreement, charter party or the bill of lading?
Charter party agreement.
In that there is an arbitration clause. Whether that clause can exclude the Admiralty jurisdiction of High Court?
Your Lordship, as per it has been clearly stipulated in the facts of the case that the seat of arbitration regarding all the general average and any other issues should be handled under the arbitration seat, which is at the London. So it has been agreed by both the parties, including the brokers, and they have entered into an arbitration clause with that agreement. So since such an agreement for such an arbitration clause exists in time, the my humble
then
opinion
whether that clause excludes the jurisdiction, Admiralty jurisdiction of this court?
Yes, Your Lordship.
What is your contention?
If
that clause is there in the charter party agreement, contract, then whether that clause excludes these courts' Admiralty jurisdiction?
Indeed, Your Lordship. Since such an arbitration clause.
Suggest some of the case laws.
Sorry, Your Lordship, the council is not well versed with that case law. Only similarly in BGS, as I have already mentioned, the BGS and SGS Soma GG versus NHPC case said that since there is a seat of arbitration, if a place has been named and identified, then
those cases suggest only where the arbitration should be happened. That kind of things is there in that precedence you suggested, but we want a clear precedent that if there is a charter party in a charter party contract, if there is a arbitration clause, then it should evade the jurisdiction of a Admiralty court.
Sorry, Your Lordship, the council is ignorant of that.
Okay.
If the bench is satisfied with if the bench has no more questions, shall I move on to my second issue?
Yes, definitely.
The council represents the second issue as is the declaration of general average legally sustainable if the vessel is unseaworthy. The council for the respondent most humbly submits before the Honorable Court of Indo that the declaration of general average is legally sustainable if the vessel is seaworthy. The seaworthiness of the vessel helps to obtain the general average. The carrier shall be bound before and at the beginning of the voyage to exercise due diligence to make the ship seaworthy, properly mean equip and supply the ship and make the hulls refrigerating every other aspects of the ship and all other parts of the ship in which goods carried fit and safe for the reception, carriage and preservation before the commencement of the voyage itself. So the concept of seaworthiness generally measures the ability of the ship to complete the voyage stipulated by the contract of carriage, conditioning that the obligation is non-delegatable. The due diligence needs to be exercised before and the beginning of the voyage. Also, it is an overriding obligation that the absence of which will not entitle carrier to avail the immunities. So in this case, the claimant and the ship owner were the parties in the charter party agreement. The ship must be a seaworthy state which suits the terms laid down in the charter party agreement. So it is clear that the vessel was seaworthy at the commencement of the charter party agreement and voyage. Also, neither the carrier nor the ship
How
shall
can
be
we
liable.
how can we say that the ship is seaworthy as far as the owner or the owner of the ship is concerned?
The measure of seaworthiness is conducted by the owner by checking all its parameters such as physical seaworthiness, the human resource seaworthiness, and all the documentation seaworthiness. Seaworthiness is a concept which makes the ship fit for getting the ship from safely landing to the destination without causing any damages during any perils occurred on the sea. So the ship owner before the commencement of the voyage ensures that every part, every limits of the cargo, that is, every ship has a stipulated amount of cargoes that are to be loaded onto the ship, and all such measurements are to be checked and verified by the ship owner. So in this case also, the ship owner had made already, it has been mentioned in the charter party agreement that the vessel is seaworthy before the commencement of the voyage. The owner has checked, and only after that he had loaded the cargo. If that ship was an unseaworthy ship, according to the implied provisions, it shall not be sent for a voyage.
Yes. Then your argument is that this ship is
Seaworthy.
yes.
So also there was no defect in the charter party agreement regarding the same. So the same also in this case, the vessel experienced bad weather and has listed 35 degrees to the starboard side, and due to which the master of the vessel had to jettison around 500 metric ton to 600 metric ton of cargo of methanol. Jettisoning of cargo has taken place due to the defective passage plan made by the claimant, which is the voyage through the Warsaw. Here, the ship owner will not be liable even if the vessel has become any unseaworthy.
Also, you have another question. In this case, the charter party is a time charter party.
Yes, Your Lordship.
Then, in the case of a time charter party, whether the liabilities of the owner can be limited. This is the case of time charter party.
Yes, Your Lordship.
Then what happened? What is the real scenario in a time charter party, and what is the difference between this time charter party and the voyage charter party? Whether there is any difference in liabilities of the owners?
As per the time charter party, the owner cannot be exempted because since it is a time-bound voyage, the time stipulations are to be considered in that charter party agreement. So in here, the owner had informed that they had experienced bad weather and there will be a delay also. So the time charter indicates that the charter is able to lease the ship for a certain period of time to determine the route, ports of call, and types of cargo carried within the stipulated period of time. So the charter party agreement will be laid only when the vessel is seaworthy. So the vessel was in seaworthiness for the whole voyage, and the defective passage plan made the claimant doesn't affect the seaworthiness of the vessel.
Whether the crews are provided by the charterer or the owner provides the crews of the ship. Whether any kind of, if there is any kind, yes.
Owner by the owner lordship.
Owner provided the crews.
Yes, your lordship. Owners and parties interested in MV Moonlight. It has been provided by the owner.
Oh.
If the lordship and ladyship has no more questions, shall I move on to my third issue?
Yes.
The council gives permission to address the third issue as to whether the court considering the issue is bound by sanctions imposed by a third country. So the council for the respondent most humbly submits before the Honorable Court of Indo that the court considering the issue can be bound by sanctions imposed by a third country. That according to Section 13 of the Civil Procedure Code 1908, Section 13 embodies the principles of res judicata in foreign judgment. It embodies the principle of private international law that a judgment delivered by a foreign country of a competent jurisdiction can be executed and enforced in India. So, a foreign judgment shall be conclusive as to any matter thereby directly adjudicating upon the same parties or between parties under whom they or any of them claim litigating under the same title. Section 14 states that the presumption that an Indian court takes when a document supposed to be a certified copy of a foreign judgment is presented before it. So, in accordance with the case, the sanctions imposed by a third country can be bound as per Section 13 of the Civil Procedure Code 1908. Also, the imposition of sanctions of a third country, Chapter 2 of the Foreign Trade Policy provides sanctions imposed against countries and regions. One of the key sanctions set out in Chapter 2 of the Foreign Trade Policy is that direct or indirect import to Iran or import the specified items, materials or goods from Iran is restricted. As per the case, the claimant after completion of bunkering instructed the vessel to proceed to BAK Laran for loading cargo for voyage to the west coast of Indo. There is political unrest at Laran and the military has taken over the control of the port, to which BAK is regarded as unsafe. So, Chapter 2 of the Foreign Trade Policy, as per the cargo loaded from BAK Laran will become illegal. So, hence, I humbly submit before the Honorable Court of Indo that the court considering the issue can be bound by sanctions imposed by a third country.
Can I ask you a question? Why are you saying that because the owner of the cargo suggested that you have to go to this place, you are responsible for the same? As in, how are you affected by it? What is your liability or what is your responsibility as far as the route is concerned?
Your ladyship, as far as the route is concerned, while discussing the agreement or while entering into an agreement, the route has been has to be settled by both the parties. But they have not clearly, in the fact, it has been not clearly specified about the route fixations, and later the route fixation and the claimants have asked us to lead our ways in order to load their cargo from a politically unpressed place. So the owners have to pick the cargo for loading from that politically unpressed place since their cargoes were kept there.
Have you incurred any loss or any liability for the fact that you have picked up cargo from an unsafe port?
Due to such a defective passage, we have met with jettison and due to bad weather also. But during the time of loading of cargo, the respondents have not experienced any of the losses.
Okay.
So if your bench is satisfied and has no more questions, I would like to address my co-counsel to address the issues 4 and 5.
Yes.
Counsel seeks permission to address the court.
Yes.
May please this honorable court. This is counsel number 2 from team IMC 116 appearing on behalf of the respondent in the case of Octa Limited Company versus owners and parties interested in MV Moonlight. Your lordship and ladyship may continue from where my co-counsel left.
Yes.
Much obliged, your lordship and ladyship. I would be dealing with issues number 4 and 5 and will speak for 20 minutes. Issue number 4 deals with, since the claim for short delivery of cargo is raised before a court, where a counterclaim is also raised by the owners demanding GA contribution, whether the court can adjudicate on the rival claims considering the fact that the alleged damage occurred within its territorial waters. The counsel for the respondent most humbly submitted before the Honorable Court of Indo that the court cannot adjudicate on the rival claims such as short delivery of cargo and the owner's demand on general average contribution, considering the fact that the alleged damage doesn't occur within its territorial waters. As per United Nations Convention on Law of the Sea 1982, territorial sea is a belt of coastal waters and the territorial jurisdiction encompasses territorial waters up to 12 nautical miles from the closest baseline point. Those 12 nautical miles is approximately 22.22 per kilometer. Surely, a vessel can cover those 22 kilometers within hours. And if the jettison of cargo was occurred within the territorial waters, the vessel can surely arrive at the Mumbai port on 10 July 2021. But here, the vessel arrived on the Mumbai port on only 11 July 2021. That means the vessel took 1 day to reach the Mumbai port after the jettison of cargo. So it is clear that the jettison of cargo did not happen within the territorial waters and it happened on the high seas. And there is a case, Enrica Lexi case. On that case, Italy challenged the arrest before the Kerala High Court, alleging that India had no jurisdiction to try the case at the very first instance, as the incident happened not in the territorial waters, but on the international waters. And in this case, the claims apprehended by the claimant were the short delivery of cargo and the demand of general average by the ship owners. Those claims were happened at the Indus territorial water, but that was evolved from the jettison of cargo. The jettison of cargo is the most important action and it's the main action that was took place in this case, and that was happened on the high seas while the voyage towards the Mumbai port. That means there is no affirmation on the actual place of occurrence of jettison of cargo. And when it comes to the legitimacy of arbitration clause in the Charter Party Agreement, there is a case, Bharat Aluminium Company versus Kaser Aluminium Technical Service. In this Balfour judgment, it was laid down that the Indian courts cannot grant interim relief in the case of foreign seated arbitration. And as per Section 34 in the Arbitration Act.
Does the flag of the vessel has any relevance to the jurisdiction?
Your Lordship, the vessel was had a flag state and the Indus ship, but the particular action, the jettison of cargo was happened in the territorial waters of the state, and that will surely will be a base on that in this case. So the flag state didn't make any important thing in this case. The action jettison of cargo is the main, and that jettison of cargo is the main action, and the rival claims claimed by the petitioner was arised from this jettison of cargo. So that will be the main.
What is the purpose of this admiralty jurisdiction?
Admiralty jurisdiction was happened because of the short delivery of cargo.
What is the purpose? Generally, what is the purpose of this admiralty jurisdiction?
Admiralty jurisdiction, actually this admiralty jurisdiction will not be valid because there is an arbitration clause that was seated in the London.
My question is very clear. What is the purpose of admiralty jurisdiction? General context, not in this case. What the Act says, 2017 Act says.
The purpose of admiralty jurisdiction
purpose of this Act, 2017 Act.
secure the claims only for the security furnished to the petitioner. That's the only thing, that purpose of the admiralty jurisdiction.
Not clear.
The jurisdiction with respect to maritime claim under the bill will vest with the respective high courts and will extend up to territorial waters. So,
if that ship is within the territory of the state, then it can exercise jurisdiction.
Your Lordship, as I said, there is no affirmation on the actual place of occurrence of the jettison of cargo.
That is not relevant. If the ship is within the territory of that particular court, then that can exercise jurisdiction. If it is in a foreign state, it cannot exercise.
Your Lordship, the cause of action will be the main reason behind the case. So that's why. And there is an arbitration clause also in this case. So the admiralty jurisdiction will not stand and the Admiralty jurisdiction will not become valid. The seat of arbitration is London, and the
That
parties
is
should.
already dealt by your co-counsel in the first issue.
Uh, um, in this charter party agreement, it's clearly mentioned that all disputes, including general average contribution and everything, should be resolved in the seat of arbitration in London. So that Admiralty jurisdiction will not stand, and that there had an arrest of ship, but that's only for the security of maritime claim. But later it will not be stand.
Yes.
Much obliged, Your Lordship. And in the case of Rishabh Ship International LLC versus MV Eagle, the Honorable Bombay High Court relied on the precedents laid down in the Balcourt judgment, and it was held that Indian courts do not have any power to pass interim orders in the cases of foreign seated arbitration. So hence it is humbly submitted before the Honorable Court of Indore that the court cannot adjudicate on the rival claims, considering the fact that the alleged damage doesn't occur within its territorial waters. Your Lordship and Ladyship, if there are no further questions, may I please
But
move on to the next issue?
I think Rishabh International was the case before the Admiralty Act was in place, right? So what after the implementation of Admiralty Act 2017, what is the effect on the jurisdiction of the High Courts in Admiralty matters?
Your Lordship, sorry. Please.
Am I not clear? As in
Hey.
my voice not clear?
Yeah, it's not clear.
I'm asking you, Rishabh International was a case before the Admiralty Act was in force. What was not in force? What is the effect right now when there is an act in force? The act specifically provides for the jurisdiction of the High Court in specific instances.
Your Lordship, in this case, the territorial waters is the main aspect in this particular issue. Whether the territorial waters consider the Admiralty jurisdiction, etc. But here, there is no affirmation. So we cannot say that it will come under the Admiralty jurisdiction and territorial waters. So.
You suggested another case, MV Enrica case. That also the dispute is in that case the dispute is only with regarding the criminal jurisdiction. All the Admiralty matters already settled. The court already settled their matters.
Your Lordship, in that case, our country had as an obligation to every citizen. That is a murder case. Fishermen were dead, and India has to safeguard the right.
We are not concerned about that things. We only concerned about the Admiralty claims, civil matters. The case is only the dispute in that case is only with regarding the criminal jurisdiction. We are not related with that. We are trying to adjudicate a maritime claim. And
Your Lordship, we had only Your Lordship, we had only pointed out the territorial waters and international waters, that area. That was happened on the international waters, and here also it was happened on the high seas.
Wherever it may be, the vessel is presently within the jurisdiction of this particular court. Then what is the barrier to exercise jurisdiction?
Your Lordship, yes, the ship was in the Mumbai port and in the territorial waters, but the damage occurred. The damages was happened when the cargo was jettisoned. That means shore delivery of cargo, and the GA contribution also had evolved from the same. So the damage occurred is not in the territorial waters, and that will be the base in this case.
Yes, proceed.
Shall I move on to the next issue?
Yes.
Much obliged, Your Lordship. Issue number 5 deals with does the provision of the Arbitration Act exclude an action in rem from its purview as non-arbitrable? The counsel for the respondent most humbly submitted before the Honorable Court of Indo that the provisions of the Arbitration Act does not exclude an action in rem from its purview as non-arbitrable. A right in rem means right exercisable against the world at large, and in contrast, a right in personam is one exercisable against a specific individual. In personal proceedings, this decide the personal rights and interests of the parties named in the action, whereas action in rem are directed against the property itself and determine the rights of the parties exercisable against the public at large. In a case, Bose, Allen, and Bimal Kishore Shah and others versus J.S. Dinesh Shah, the court concluded that traditionally all disputes relating to right in personam are considered amenable to arbitration, and all disputes relating to right in rem are required to be adjudicated by courts and public tribunals. But the court clarified that this is not an inflexible rule, and that subordinate rights in personam arising from right in rem have always been considered as arbitrable. In this case, the dispute between the claimant and the ship owner arose from the jettison of cargo due to the bad weather condition faced by the vessel. Here, the ship owner will not be liable for the consequences faced due to the same, and the issue will come under the purview of action in rem. Section 5 of the Admiralty Act pertains to the arrest of vessel in rem, and action in rem is an action directly against property as a defendant. And in a case, Ocean Liner was MV Golden Progress, the court stated that the right to arrest the ship is right in rem, whereas application filed against the individual under arbitration law is right in personam. In term of Admiralty Act, arrest means detention or restriction for removal of a vessel by order of a High Court to secure a maritime claim, including seizure of a vessel in execution or satisfaction of a judgment or order. The rationale behind the provisions contained in Section 5 of the Act is to obtain security for maritime claim, which is the subject of an admiralty proceeding. Hence, it is humbly submitted before the Honorable Court of Indo that the provision of the Arbitration Act does not exclude an action in rem from its purview as non-arbitrable. Your Lordship and Ladyship.
Yeah, arbitration. Is there anything in the Arbitration Act which says that, the arbitration court can pass an order arresting or order of arrest of a vessel?
Your Lordship, may you please repeat the question?
Here, there's an action in rem, right?
Yes.
Action against the vessel. Is there anything in the Arbitration Act which confers power on the arbitrators to pass an order arresting the vessel?
Pardon, Your Lordship.
What Section 5 of the Admiralty Act says? (5)(e). Am I not audible?
Yes, yes, Lordship.
What does Section 5E of the Admiralty Act say?
Interim relief
Interim relief?
by the court for a foreign seated arbitration
Correct.
by the court. Your Lordship.
With respect to?
With respect to foreign seated arbitration, the court can grant interim relief to the cases.
Correct. So as far as the action in rem is concerned, in this case, shouldn't we exercise jurisdiction under the Admiralty Act?
Your Lordship, there is no ground to act Admiralty jurisdiction in this case because there is an arbitration clause, and the interim release that granted will not become valid because of the arbitration clause in the Charter Party Agreement.
But
So-
Section 5E confers power on us. How do you get over Section 5E? Is there any case law or any act or anything which shows that, or for you to show that I don't have power under Section 5E? Or if you
Pardon, Your Lordship.
some case laws which says that an arbitration court has passed an order similar to that of the powers confined under Section 5E.
Uh,
I think that is the
Sorry, Your Lordship.
that is the issue.
Yeah. Uh, Sorry, Your Lordship. I'm not aware of it.
Okay.
Shall I move on to the trial?
Yes.
Much obliged, Your Lordship. Therefore, in the light of the facts stated, issues raised, arguments advanced, and authority cited, it is most humbly prayed and implored before the Honorable High Court of Indo that it may be graciously pleased to adjudge and declare that the exercise of Admiralty jurisdiction is not valid and reasonable. The declaration of the general average is legally sustainable and it should be maintainable. The sanctions imposed by a third party are bound by the court and it should be levied. The court cannot adjudicate the claims by considering the damage occurred within the territorial waters and it should be challenged. And the arbitration doesn't exclude action in drum as non-arbitrable and should be quashed. Also pass any other order that it may deem fit in the favor of the respondent in the light of the equality, justice, and good conscience. And for this act of kindness, the counsel for the respondent shall be duly bound forever to pray.
Do we have time for rebuttals? Do you have rebuttals?
Sorry, Your Lordship.
Your Excellency,
Since both teams have presented with their initial arguments, if Your Lordships permit, may we proceed to the rebuttal session?
Only if the petitioners, the claimant has rebuttals.
the council seeks permission to move to the rebuttal.
Team 106 have a total of 15 minutes for the rebuttal based on their apportionment of time. You may start now.
Your Excellencies, the learned counsel for the respondent substantiated that the exercise of admiralty jurisdiction by the court is not valid because the charter party involves the prominence of an arbitration clause. However, as I had previously stated, the case of JS Ocean Liner versus State of Bombay had decided that the arrest of a ship is a right in rem. Therefore, the Indian courts can arrest the ships despite the fact that there exists an agreement for foreign seated arbitration. I would also like to mention that in the respondent memorial submission, the learned respondents in issue 1 had argued that in view of the arbitration clause, the courts cannot exercise jurisdiction. However, in issue 5, they have stated the case of JS Ocean Liner versus State of Bombay and mentioned that the Indian courts can arrest the ship, despite the fact that there exists an agreement for foreign seated arbitration, effectively contradicting their own arguments between issue 1 and issue 5. And this renders their stance unclear. This case has been mentioned in page 21, paragraphs 5.2.3 of the memorial of the respondent. The learned counsel of the respondents have also argued that there is no evidence to prove that the jettison of cargo has happened within the territorial waters, so that the exercise of admiralty jurisdiction by the court is not valid. However, the present counsel would like to state that as per the Moot proposition, the issue 4, which has been drafted already, states that states explicitly that the alleged damage occurred within the court's territorial waters of the court's jurisdiction. Therefore, this goes against their argument. Furthermore, several important indices, such as the size of the vessel, the speed or the number of knots it was traveling per nautical mile, was not stated in the Moot proposition. Thus, it cannot be assumed that the jettison occurred in international waters. The learned respondents have also argued that have also relied on the Hague-Visby rules. It is to be noted, however, that the parties have agreed to enter into the NYPE form of contract with York Antwerp rules to adjust their general average. Furthermore, regarding issue 3, the learned respondents have relied on section 13 of the Civil Procedure Code 1908, which lays out the concept of foreign judgment. A foreign judgment is not the same as a foreign sanction. Hence, section 13 of the CPC cannot be applied. Sanctions cannot be considered or treated as law. Furthermore, Your Excellencies, the learned respondents cannot assume that Iran stated in the problem is the actual country Iran, as the problem does not paramateria mention that the country Iran is Iran. And also, as per issue 4, the territorial jurisdiction cannot apply to general average as the subject matter is seated for arbitration at Lloyd's London. Your Excellencies, it was an honor pleading before this court.
If IMC 106 is done with their rebuttal, we'll move on to the sub-rebuttal. Team IMC 116 has a total of 5 minutes as based on the apportionment of time. You may start.
As my as the speaker has said, for the first issue, that admiralty jurisdiction has an comes with a contradiction with the issue 5. The issue 5 is that the provisions of the Arbitration Act exclude an action in drum from its purview as non-arbitrable. But the actual issue of issue 1 states that about the jurisdiction of the Admiralty Court, whether it is valid or not in view of an arbitration clause. So the provisions of Arbitration Act clearly excludes an action in drum from its purview as non-arbitrable. Secondly, while mentioning the fourth issue, the opponent speaker had mentioned that whether the court can adjudicate on the rival claims considering the fact that the alleged damage occurred within its territorial waters. But the facts of the facts does not clearly state that it has happened in territorial waters, or no other supportive evidences has been placed except this sentence that it has been alleged damage, that the alleged damage occurred within its territorial waters. Regarding the issue 3, whether the court considering the issue is bound by sanctions imposed by a third country, as per chapter 2 of the foreign trade policy, it has been mentioned that sanctions imposed against countries and regions. One of the key sanctions set out in chapter 2 of the foreign trade policy is that direct or indirect import of Iran or import of specified items such as materials can be restricted. Since the law of Indo is parameter to the law of India, any law that restricts or imposes on India can also be impliedly restrictive of the portions that has been, or any country that restricts any sanctions can also be fall upon the imaginary states such as Iran also. Then about the section 13, the purpose of civil procedure code, in this case any sanctions imposed by a third country, even any sanctions may also include that any judgments or foreign orders or awards that has if the according to CPC, if any of the awards that has relevance to exercise in the jurisdiction under our court, then any sanctions imposed by such a third country is also applicable to us.
Since we are done with the session, with the permission of the court, let me inform the team that it is time for the tabulation. So the teams may please leave the court for further instructions, and the team managers may intimate you to re-enter the courtroom. Kindly leave the courtroom, participants.
Thank you, Your Excellencies.
Thank you, Your Excellencies.
Thank
It was
you.
an honor pleading before this court.
Thank you.
Thank you, Your Excellencies.
Your Lordship, I hope that the tabulation sheets are handed in. And if there is any ambiguity, please feel free to intimate it to us.
Has a participant left the meeting? All of them?
Shall we put mark together, Parvati?
അതെ അതെ
What is
yes
നമുക്ക് ഒരുമിച്ച് ഒരു കൺസെൻസിൽ എത്തിയിട്ട് മാർക്ക് ഇടുന്ന കിട്ടില്ലേ?
അതെ അതാ നല്ലത്.
അങ്ങനെയാണെങ്കിൽ ഫസ്റ്റ് ഗ്രൂപ്പിനെ അങ്ങനെ നമ്മുടെ
speaker 1 in the knowledge and understanding of the facts and legal issues.
ടീം 106 സ്പീക്കർ ആ സ്പ്രെഡ്ഷീറ്റ് എടുത്തോ? ഞാനും എടുത്തു. നോളജ് ആൻഡ് അണ്ടർസ്റ്റാൻഡിങ് ഓഫ് ഫാക്ട് ആൻഡ് ഇഷ്യൂസ് ജസ്റ്റ് ഏവറേജിനെ പറയാൻ പറ്റുള്ളൂ.
അതെ
അങ്ങനെയാകുമ്പോ ഏവറേജിന് എത്രയായിരുന്നു മാർക്ക് പറഞ്ഞിട്ടുണ്ടായിരുന്നത്? എക്സലൻസിന് 16 മുകളിലേക്ക് എന്നല്ലേ പറഞ്ഞിട്ടുള്ളത്?
അങ്ങനെയാണ്. മാക്സിമം 20 എന്നല്ലേ? ഓ ഇതിനൊരു ഇതും ഉണ്ടോ? അതെവിടെ പോയി? അതിന്റെ മൂഡ് പ്രോബ്ലത്തിലുണ്ടാവുമായിരിക്കും.
ഇവര് ഇതിപ്പം ലൈവ് സ്ട്രീം ചെയ്യുന്നുണ്ടോ?
അയ്യോ ഉണ്ട്.